There are two different kinds of fraud in bankruptcy. One is fraud where the debtor has defrauded creditors, and that typically happens prior to filing the bankruptcy petition. And in individual bankruptcy cases, that can give rise to non-dischargeability actions. And the other is fraud in the process of the bankruptcy case, fraud on the court. So let's take the first one, fraud on creditors. There are some technical definitions. The gist of it is we've got two working definitions. The first is the classical definition of fraud. A debt's incurred through fraud if at the time you incur the debt, you make a material misrepresentation that induces a creditor or a lender to extend credit or lend money to you, and that entity wouldn't have done so but for the lie. That one doesn't come up as frequently as the other working definition in dealing with creditors, and I'm going to give more of a folksy definition here than a technical definition. The gist of it is a debt's incurred through fraud if at the time you incurred it, you had no intention of ever repaying the debt. Now, of course, how do you know what another person intends? It's not so easy to read people's minds. So typically, the analysis involves looking at certain kinds of pre-petition behavior. By pre-petition, I mean, well, the day we file the bankruptcy petition is the petition day. Prior to that is pre-petition. After that is post-petition. So, for example, if you rack up a bunch of new debt and shortly thereafter file for bankruptcy protection, the presumption is you didn't intend to repay it at the time you incurred it. Or if you rack up a bunch of debt and you have no visible means of ever repaying the debt, then the natural question is, well, how did you expect eventually to repay this debt? And if you have nothing that you can point to, the presumption is that you didn't really intend to repay the debt at the time you incurred it. So that is the pre-petition fraud debt to creditors. And in an individual bankruptcy case, an individual debtor schedules the debts, and the creditor then has an opportunity, if it so chooses, to challenge the discharge of that debt under a theory of fraud. As I said, the other kind of fraud that we deal with in bankruptcy is maybe thought of under the rubric of fraud on the court, where you've lied in your bankruptcy petition, you've hidden assets, you've misrepresented the facts, you've lied at the hearing or hearings as the case may be. And that can give rise to denial of the entire discharge, as opposed to the denial of the discharge of just that one individual debt to that one individual creditor that you defrauded. On top of that, when you engage in fraud on the court, that can open you up to the possibility of getting free room and board at taxpayers' expense, because if you have committed perjury and the Office of the U.S. Attorney decides to prosecute, you can end up in a federal penitentiary. Now, the good news is it's in a federal penitentiary as opposed to a state penitentiary. I don't actually have any experience with penitentiaries. I've never taken a criminal case, but I have had bankruptcy clients who, prior to becoming my bankruptcy clients, had in some cases spent years in penitentiaries. And they have assured me that the food is better in the federal penitentiaries. But my general piece of advice is, why don't we just take my former client's word for it, and you tell the truth and this won't be an issue. I guess the long and short of it is, it sort of depends on the context as to which definition of fraud we're using. And one of the things we do at a first meeting is an analysis of the debts to see, is there going to be a problem? And also, I tend to really encourage my clients to be forthright and honest in the bankruptcy petition.